Today, let us discuss Article 202 to Article 207 relating to introduction and passing of annual budgets in the state legislatures. We popularly call it as budget, but in constitutional parlance, it is an annual financial statement. Under Article 202, it is the governor who is responsible to introduce or caused to be introduced the annual financial statement in the assembly of that state. This annual financial statement, which we call as annual budget, would contain all receipts and expenditure of the state for the coming year. Usually, it is introduced in the month of February. It should separately show the revenue receipts and revenue payments and capital receipts and capital payments separately. The assembly may pass the annual financial statement as it is, or it may pass with certain amendments, or it may altogether reject it. When it is passed as it is, then the allocations will be made as proposed in the annual financial statement. If the assembly passes the bill with modifications, then also it is deemed to have passed with modifications, and accordingly funds would be drawn from the consolidated fund of the state. Governor is the custodian of the consolidated fund of the state. While discussing these incomes and expenditure of the state, there are certain amounts which are charged on the consolidated fund of the state which do not require approval of the state legislatures. However, there is no prohibition on discussion about such expenditure which are charged on the consolidated fund of the state. Such expenditure are the salaries and expenditure of the office of the governor, the salaries and expenditure of the office of the speakers of the assembly and chairman of the councils, and other payments which are occasioned on account of any judgment of a court or a tribunal, and all other payments which are necessitated to satisfy any debt, repayment of debt, interest, etc., and the salaries and expenditure of the offices of the High Court judges. These are the amounts which need not be passed by the legislatures. They are charged on the consolidated fund of the state, and they have to be paid irrespective of other incomes and expenditure. Regarding all other expenditure like salaries of the employees of the state and other proposed expenditure on account of development or social welfare, they will be discussed in the assembly and the council, and they will be passed accordingly. A situation may arise, an allocated budget may not be sufficient for any particular project or proposal, then additional proposals would be put, but no such additional proposal shall be proposed in the legislatures without the consent of the governor of that state. And another provision is that there will be vote on account. When it has not been possible for the assembly to consider the annual budget, or when it is not possible for the governor to introduce his budget, in such case the assembly is empowered to make allocations for different projects on a temporary basis. But there are certain takeaways from this process. This is called an annual financial statement. So all your incomes and expenditure will have to be planned in advance for the coming year. It is important not only for the government, it is important also for the citizens. Depending on the tax proposals, etc., the citizens also have to plan their financial affairs. The union government is following this principle strictly. Through budget only, they are making allocation of incomes and expenditure. Whereas state governments are concerned, it has become a fashion nowadays. Whenever money is required for distribution of freebies or for some other projects, simply the state governments are issuing circulars, departmental circulars in the form of GOs to collect additional taxes. But please understand, taxation is a legislative function and it has to be exercised only annually. If you start imposing taxes in the middle of the year, the businessmen may not be able to plan their businesses accordingly. This GO, these two words GO are the most misused terms in the states. GO means it should be a governor's ordinance issued under Article 213. Ordinance will be in existence for 45 days after the reassemble of the assembly, and it has force of law. Whereas the misused term GO is a government order. These are being issued by the departmental heads, namely the secretaries of different states. This is a mischief, unconstitutional and illegal behavior of the state governments. You can find plethora of examples of this kind in Telugu states. For example, Telangana government has issued GO number 147 of 2020 imposing trade license fees based on the plinth area of the shop and width of the abutting road. See how illogical it is. Business or profits are not proportionate to the plinth area of the business and the width of the abutting road. Moreover, in terms of Article 276 Clause 2, state governments cannot impose any tax, fees, cess or anything exceeding 2,500 rupees per person. Whereas this plinth area measurement for hotels, it may come to 50,000 to 1 lakh square feet. If it is a 1 lakh square feet, the price is fixed at either 3 rupees, 4 rupees or 5 rupees per square feet basing on the width of the abutting road. So for 1 lakh square feet, you will have to pay 5 lakhs. Whereas the limit imposed by Article 276(2) is only 2,500 rupees. Taxes cannot be imposed through GOs, that is a legislative function. If it is a fees, cess or some other charge by the municipalities and the local bodies, they are not treated as money bills and they can have their own charges. But whereas the Honorable Court, in the case of Hotel Owners Association Secunderabad versus State of Andhra Pradesh, decided that if the charge is compensatory, that means if it is charged for any service made by the local bodies, such charge shall be reasonable and shall have some relationship of quid pro quo. It should be proportionate to the service rendered. If the fees is for controlling purposes, then it should be nominal. So violating all these principles, the states are charging exorbitant amounts. Before somebody approaches the court and gets an order, it takes 1, 2, 3 or 4 years time. In the meanwhile, thousands of crores of rupees being squeezed, wrung from the innocent, gullible traders. This is wholly illegal. The other takeaway from these articles 202 to 207 is that it is the president, it is the governor of that state who has to introduce the budget or anybody of his assigns. Without his permission, any demand for additional expenditure cannot be proposed in the legislatures. Now you must understand under whose control the finances of the state are. He is the in charge of the consolidated fund of the state, and without his permission, additional expenditure cannot be introduced in the legislatures, and it is he who should introduce the budget. We are seeing in states the chief minister, while in election campaigns from the electoral diocese, he declares so many freebies. How does he do that? Any expenditure has to be laid in the annual financial budget with the approval of the governor of that state. This way, their quest to win the elections, they are emptying the coffers of the state, which is impeding the development of the state. It has a cascading effect. No government would be able to satisfy the citizens with their services and development. No amount of money is sufficient to distribute freebies. And who after all is a chief minister to announce a freebie? It is after all public money. It has to come through the budget and it has to be discussed in the assembly so that opposition parties also will have a say on that. Of course, they don't ask you to reduce the welfare schemes. Instead, they ask to give more and more. I told you it is the governor who proposes the budget. I have always been telling all along my lectures that Indian polity consists of two sections. One is the ruling section and the other is opposition section. What is ruling section is represented by the president and his union ministers and the parliament members belonging to that political party. In states, the party of the President of India is represented by the governor and his appointed ministers and the assembly members who have won on the ticket of the party of the president or its coalition. The other is the opposition party. When opposition parties are in majority in an assembly, it becomes difficult for passing a budget because budget is proposed by the party of the governor. This is the party of the president, and the opposition may not like it. They don't pass it or they don't attend the assembly. So the finance bill would not be passed. It is this kind of situation which is envisaged under Article 356. If a financial budget cannot be passed, the people will turn against the opposition parties because employees do not get their salaries and the beneficiaries would not get the proceeds of social welfare schemes, and the development of the projects will be impeded. So entire people will turn against the opposition parties. With that fear, usually the opposition parties would not oppose these financial bills. If they still oppose, then the course is to make a declaration under Article 356. So suspending the assembly and suspending the government for not being tactful in getting the budget passed. Then what happens? The functions of the assembly are taken over by the parliament or its assigns, and the functions of the government, namely the governor, his ministers, etc., is taken over by the president or his assigns. The constitutional fathers rightly envisaged such a situation and kept the period of duration of declaration under Article 356 for 3 years. This kind of situation is not desirable even for the opposition parties. As such, usually they would cooperate in passing the budgets. Otherwise, even they do not get their salaries. If the assembly is dissolved, the opposition party members who are in majority, they also lose their memberships. Their memberships are kept under suspension. It can be kept for 3 years. Without knowing this constitutional scheme, the Janata Party, under the pretense of protecting the democracy, has brought 43rd constitutional amendment to reduce the duration of 3 years to 1 year under Article 356. Unfortunately, in many cases I have seen Article 356 is being used either for political purposes or for law and order situations in the states. But the purpose of Article 356 is not that. Article 356 says that the President of India, on the report of the governor or otherwise, if satisfied that the administration of the state cannot be run in accordance with the provisions of the Constitution, he may make a declaration under Article 356. That means he will suspend the assembly and the government. This is the purpose of Article 356. For law and order situations, there are already Article 355 is there. Central government can send its forces and subdue the law and order situation in the state. This logic of two sections of the Indian polity, the official party and the opposition party. Official party is always represented by the president, his ministers, governor and his ministers, and the legislative party members belonging to that party or that coalition is the official party. The other is opposition party or opposition coalition. This simple logic Indians fail to understand, miserably failed to understand, and made mess of democracy and Indian polity. If a person who holds majority in the legislatures rules, it will be disaster. It will be one-sided. There will be oppression, corruption, family rule, individual rule. That is not democracy at all. Somebody becoming chief minister with majority in the assembly and somebody is becoming prime minister with majority in the parliament is contained in Article 91 and 130 of the Pakistan Constitution of 1973. But such a condition is not there under Indian Constitution. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. My purpose is to bring to the notice of the citizens of India, the true purport and intent of the Constitution. I have studied Constitution intently for 3 years and wrote 2 books, one in English and one in Telugu. Indian Politics versus Indian Constitution in English and Bharata Prajalamagu Memo in Telugu. These 2 books were published by Notion Press Chennai and they are available online throughout the world on Amazon, Flipkart, Kobo, etc. platforms. Thank you. Thank you for watching my video. Thank you.